Being a leader comes with challenges. The Leading to Win podcast will help leaders make wise decisions by leading to win. Here's your host, Marty Haynes.
Welcome to Leading to Win, where our goal is to help you become a better leader. And today, once again, we have Joanie Winters from Winters Law Firm with us today. Joanie, as always, thank you, ma'am, for taking the time to be with us today.
Thank you for having me, Marty. It's always a pleasure.
We're going to talk about something today, and it's called fire at will. And we're not talking about shooting somebody. Thankfully, we are talking about, sometimes you have to terminate, fire an employee, even though we don't like to go through that process. Sometimes we have to do it. And North Carolina and South Carolina are at will states when it comes to that. What does that mean?
That's correct, Marty. Both North Carolina and South Carolina are at will states. And it doesn't mean what everybody really thinks it means. It doesn't mean we can just terminate someone at will. We can't just say, Marty, you're fired because I can. So if you're in front of a hearing officer for the unemployment office or the Equal Employment Opportunity Commission, and you tell that investigator or that hearing officer that you fired Marty because he's an at-will employee, that's not going to be accepted as a reason. So in 2004, South Carolina, and then shortly after that, North Carolina adopted actual legislation, meaning a law that said, if you do certain things, that you can protect your employee handbook from becoming called a contract. So it really didn't give you carte blanche to fire people. It gave you protective devices for your employee handbook from being called a contract. So it really didn't have anything to do with firing at will. Now, the concept of firing at will is that you can fire someone for a good reason, a bad reason, or even no reason at all, as long as it's not an illegal reason. So I can fire you theoretically because I don't like the color of your shirt, but I can't fire you because I don't like the color of your skin.
Yeah. Okay. So let's take it from there. What are, other than race, what are some issues or some things where you cannot fire somebody for?
Okay. And so that's all governed by a law called Title VII. Title VII is the bundle of discrimination laws that come out of the Civil Rights Act of 1964. So not something new. Now it's been added on up to as most recently as last year, but it covers what's called protected classes. And those protected classes include race, color. Now, race and color are different, okay? You can be an African-American light-skinned, okay, or African-American dark-skinned, and there's a discriminating factor in there. So you've got race, color, sex, and notice I said sex and not gender, age, religion, disability, genetic information, sexual orientation. That's something that the Supreme Court just sanctioned just recently. And I think I covered all of them. I think I got all of them. So yeah, they are called protected classes.
Okay. So those are classes. Now, if I reported an injury and it got the business in trouble, and then can you just fire me for that? What goes on with things such as that?
So now you have a law that is a state law, the workers' compensation law. So if you're injured at work and I fire you or even discipline you for filing a workers' comp claim, that's retaliation under the state workers' comp law.
Okay.
And I can't do that.
Can't do that. So there's several things you have to keep in mind. That was one, or being a whistleblower. I've kind of written down some things. I mentioned something to you that I think I need a pay raise, and then you say, well, let me get rid of Marty because he's wanting more money. You have to watch when you let somebody go, what surrounds that. So I'm assuming, since you're a lawyer, you're going to tell me document.
I am. And I'm also going to tell you, prepare. Now, there are terminations you can't prepare for. So when somebody's leaning against the corner of your building, setting it on fire, you're not going to prepare for that termination. That's pretty much on the spot, right?
Mhm.
If you've got someone who is tardy, rude to your clients, and it's been building and you've been documenting their performance,
Mhm.
you're going to prepare for that termination with some additional documents of your own, checking your policies, making sure that this termination is the right thing to do. So, you mentioned, you started off this conversation with the laws. So just because you have a policy that says you, Mr. Employee, cannot discuss your wages with other employees, well, that's a policy that violates federal law.
Mhm.
And so you can't have a policy, obviously, that contradicts state or a federal law. So you always want to be careful, get yourself prepared before you sit down and fire somebody, because you don't want to be surprised by something that you didn't read, didn't prepare
Mhm.
for.
You also want to be careful, and this, most of our clients wouldn't necessarily do these kinds of things, but fire someone for because they didn't want to break the law on your behalf, do some things that within the business may have been illegal. You wind up getting a subpoena, and that employee went in and told whatever they needed to tell. You those kinds of things you also have to watch as well.
That's correct. That's called a violation of public policy. And so even though your employees are at will and theoretically can be fired for no reason, bad reason, good reason, if you're asking them to violate public policy and you fire them if they violate or they do what they're threatening to do, classic example is jury duty. We see it all the time. The employee gets a notice for jury duty. The employer says, I don't care that the court wants you there on Monday. I need you here on Monday. And if you don't show up, you're fired. As a violation of public policy. And if that employer fires that employee for going to jury duty, that employer is going to be in trouble.
Mm-hmm. Okay. I can see as an employer how, and I'm sure you get these, even though it's a fire at will state, and employers got a little bit of some room here, as long as you're not being discriminatory, or you use the going to got to go to court or jury duty or whatever. I can understand why employers will pick up the phone and call you just to make sure, even at a fire at will state.
Yes, we get those questions all the time. I every day, I usually get one or two calls like that, and it's usually on a Friday. I'm not sure why, but we'll get those calls where the employer will walk me through the history of the performance issues or whatever issue that employee may be having, and then I can counsel them and say, okay, but if you don't have any disciplinary notices, this employee does not know that you're not happy with performance, I would wait and put a performance improvement plan together. So we kind of strategize before they actually terminate. And most of the time, the termination goes cleanly and without follow-up litigation.
That's a key thing you said. When you're going to have to do this, you need to prepare. Don't do it off the cuff. Don't do it when you get mad. You need to sit down and really, get everything lined up.
Agreed. Even that person who's lighting your building up with a match, sit them down somewhere and gather your thoughts and think about what the right thing to do is, how to handle it, just to avoid litigation or some type of administrative charge.
And those types of things. Got a couple of bullet points. Should you put a termination letter together, termination meeting? What does that process look like when you need to do it? What's the best way to do it?
I like a termination letter, and one that's very specific. So it should include the reason for termination. And I'm told a lot by clients, well, I don't want to tell them why. Well, if you've done your job reprimanding the employee, they know why, and they're not surprised usually. So you need to tell them, because if you get any kind of litigation or whatever, you're going to have to tell a judge or a hearing officer. Tell the employee. So it should be in the termination letter. The termination letter should include the date that the employee is being let go, but also their date of termination. They're not always the same. So if I fire you today, but I'm paying you to Friday, your last day of employment is Friday.
Right.
And so that should be clear in the letter. The letter should not be, don't be sympathetic. And I know I sound horrible when I say that, but you don't want to say, I'm sorry, because you're not.
That was my next bullet point.
Okay.
Why does it, if an employer does this, hey, I'm sorry, John, for having to fire you today, but does it, if it gets to the legal aspect, does it look like the employer was wrong? I mean, what's the reasoning behind that?
Yes, if the employer is showing remorse, or, hey, Marty, I'm really sorry I have to do this. Well, if I sue for being terminated, I'm not suing the person who terminated me. I'm suing the company.
Right.
And so it appears that HR was sympathetic, didn't really want to do it.
Okay.
If somebody on the C-suite was twisting my arm in HR to say, fire him, I don't care how you have to do it.
Yeah.
Yeah. So, but on the other hand, I also don't believe in public humiliation. You know, that individual who has to carry out their little cardboard box.
Mm-hmm.
So you should find a way, and I don't care what the employee has done, find a way so that they can exit with some grace, whether it's by a back door or after hours or whatever the case may be.
And if an employer has to terminate someone like this, what can they expect? What if an employee goes out today, you know, they're going to get a call from a lawyer, from the Department of Labor of some sort, or what happens? What do you see happening?
Well, I always tell clients, be prepared for anything during the termination meeting and also thereafter. You'll get a variety of emotions during the term where the employee is shocked, they're surprised, they're crying, they're angry, whatever it may be. But then later, when they've had an opportunity to digest everything that you've told them, now it's a different emotion.
Yep.
Okay. And so that's when perhaps they call an attorney, or they call an uncle who knows an attorney or whatever. I've had clients who have fired people and have had a barrage of complaints filed against them with Department of Labor, OSHA, the EEOC, all sorts of agencies, the IRS, who have come in and done investigations based on these complaints. And of course, that's worst case, but you expect the worst and hope for the best.
Yeah. And what do you normally see? It's all at some point probably monetary. I mean, what's the payback? Because I'm sure in most cases the employee doesn't want their job back. What do you see?
Yeah, they don't. And so if the termination goes to an administrative claim of some sort, and you end up in a hearing or whatever, if you prevail with, let's say, the Equal Employment Opportunity Commission, let's say they file a charge of discrimination and you prevail, you don't owe that employee anything. Mm-hmm. If you don't prevail, that usually means you had to go to mediation, or you chose to go to mediation, something I don't recommend. But if you did something you shouldn't have done, I'll recommend mediation, and we'll see what it's going to cost you there. But you're right. These employees don't want their job back. Yeah. The relationship is broken.
Yeah. Okay.
And it's rare, Marty, that the EEOC orders reemployment. It is very rare.
That would be tough.
Yes.
I'm sure if that would ever happen, you know, you've got some conflict now between management and an employee that's just, you know, it rarely, I'm sure, would get better. So that would be difficult. Mm-hmm. So, you know, I'm looking at all this, you know, as an employer, HR, C-suites, you know, when they look at this, is always to make sure that you feel that the firing is justified. And then on top of that, make sure you've got your ducks in a row, you've got everything documented, because we live in an environment today where, you know, whether that employee tried to set the place on fire, they still may have a grievance and still may sue you, whatever.
Absolutely. You never know what's going to happen after a termination, which is why you prepare your defense before you even get litigation. If you don't get litigation, great, you've probably spent a little bit of time on preparing, but you're prepared. You know, if you get that litigation, you get an administrative charge, you're ready. So the other thing that I recommend very strongly is you make the termination meeting short, 5 to 7 minutes, no longer. Mm-hmm. If the employee continues to argue with you, the best tool is to stand up. It signals to the employee the meeting is over.
Yeah.
And so, at that point, the employee leaves, they have some time to think about it. That's where, they start to get angry or whatever. The minute that employee leaves and you have 5 minutes, you take 5 minutes right afterward and you write a memorandum to your file to the exact occurrence of the meeting. So what was said, what was asked, what was answered. If you don't do it, then you will forget.
Yeah.
And charges of discrimination, the statute of limitations on filing them is 300 days. That's almost a year. And you won't remember what was said during that meeting.
Right.
So it's just a good tool to put in the file. And then again, that's another thing that if you don't use, you've wasted 5 minutes.
Right.
If
That's,
needed.
I always tell our clients, especially when dealing with HR, you got a difficult job. It's not, you always got to make sure everything is in line. You may not always get it right, but somebody always told me one time about doing things, just start somewhere. You document something, keep, you might not be a writer, but you can hit bullet points and go, we talked about this, he was upset, and we talked about this and this. You can always put something down. Something is better than nothing.
That's correct.
So
that's very true. It's invaluable if you do get litigation or some kind of charge because you've got it documented.
Yeah. Okay.
Yeah.
Well, the law, being a fire at will state, gives the employers some leeway to be able to terminate those employees that rightfully need to be terminated. But even with that, I know everybody's going to see, I need to really make sure I do my due diligence. And that's the key thing. The word of the day is due diligence.
That's correct. And what I see a lot of times, Marty, is the employer has tolerated tardiness or rudeness or whatever the issue may be. They've tolerated it without informing the employee. So there are no write-ups, no reprimands, no even conversation. And then all of a sudden they've had it and they fire this employee. The employee is surprised and there's nothing in the file to document all this egregious conduct that the employer tells me existed. It's really hard to defend something like that. So due diligence starts on day one.
As I kind of wrap this up, is there a difference in anything we said versus I'm going in and I'm saying, you're fired, and they go, I quit. Does that, and if they walk out and they rethink things later and they go, oh no, you said you fired me, now I'm coming back. Does that happen?
And that happens a lot where halfway through the conversation, the employee realizes that they're being fired and they stand up and say, you can't fire me, I quit. It happens a lot. And so I had a case a number of years ago where the judge actually said that the intent for the employer to have that meeting was to terminate you. And that was the intent. Just because you jumped up and said, I quit, it's still a termination because the intent was there. So the courts recognize that, the law recognizes it, and that should be part of your memo. That halfway through the meeting, Joe stood up and said, I quit. And I explained to him, no, you're fired. And that's what the record reflects, a termination.
Yeah. Okay. I didn't know if that would change any kind of, if okay, well, you fired me now, but I said I quit, but now I decided to sue you. Does that change anything in the eyes of the law for the employer at all? I mean, does it have any weight that my intent was to fire this employee for this, but also this employee said, no, I'm not gonna let you fire, I just quit. Does any of that play into, have you seen it play into where it was a negative for the employee, even if they would have won? Does that make sense?
It does make sense. And no, I haven't seen it in particular with this one judge, and it was federal court where she drilled down on the intent. That was the point of the meeting. We weren't talking about just performance. The point of the meeting was to terminate you. And I proved that to the judge because I already had the termination letter ready with, all of the bullet points we talked about earlier, and had somebody in IT already queued up to take that employee out of the system. So we had enough evidence to show our intent And she said, no, you can say I quit all day long, but the employer's intent was to fire.
Yeah. Okay.
So it was actually a positive. It made us argue a little bit differently than we normally would have, but it actually gave us a stronger argument.
Yeah. Okay. Well, good deal. Well, I like this topic because, I'm sure it comes up every day. And I know every day, you got to deal with things like this. So in summing this up, any little nuggets right here at the end?
The one thing I would add that I have not even touched on is never do this by yourself. If you're terminating someone, you are sending them home to tell someone, even if it's just the cat, that they don't have a job after today. And so you never know what the reaction will be. Make sure you have someone with you, both from a security standpoint and as a witness. And as I always say, when you're meeting with employees, make sure you can get to the door before they can.
Yeah.
Yeah.
Exactly.
From a safety standpoint.
Yeah. Awesome. Well, good deal. Well, everybody else, like I said, fire at will topic, you deal with this every day. If there's anything that Joanie can help you with, her number is on the screen. Definitely give her a call, and she'll be glad to help you any way she can. And as always, Joanie, I appreciate you taking the time today. I've really enjoyed it.
Good. I did too. Thank you, Marty.
All right. Good deal. Everybody else, hope this was beneficial to you today. And thank you for joining us on Leading to Win. Have a good day.